Hello everyone, I'm Neha Malu from Vinod Kothari and Company. And this particular video, we are going to discuss about the recent discussion paper of IBBI, which was released on 4th of February 2024. So for the purpose of this video, we have divided into two segments. In the first segment, I'll be taking all of you through the brief background as to what exactly has been proposed, and the sequencing that I'll be following for giving a background will be as per the relevance of proposals and not as per the sequence as is given in the discussion paper. And in the second segment, we'll be doing a detailed analysis or rather a detailed discussion of what has been proposed in each of the proposals. And for that, we have Shikha ma'am and Prashita ma'am with us, who will take us through the details of each of the proposals. So, if we can move to the next slide, ma'am. Right. So right now on the screen is a snapshot of the proposed amendments. In this discussion paper, primarily amendments are proposed in three of the IBBI regulations. First one is the CIRP regulations, second the liquidation process regulation, and the third one is insolvency resolution process of personal guarantors. When I talk about CIRP regulations, now IBBI is proposing to explicitly mention about procedural coordination in case of interconnected entities. So from procedural coordination, what I'm trying to mean is, so if there are interconnected companies in a group, then for the purpose of better realization or better, for better realization of the assets of our, I mean, better procedural coordination so that ultimately it leads to a desired result. There is a concept of consolidation of the group insolvencies. Now, when we talk about consolidation of the group insolvencies, there could be two possible scenarios. One is the procedural coordination and the other one is substantive consolidation. Procedural coordination is more in the nature of code, as the name also suggests, it is of coordination of different processes in relation to CIRP. For example, appointment of a common RP or having hearings at a single NCLT bench. However, when we talk about substantive consolidation, it is completely opposite, or rather, it is more extensive than procedural coordination, where the consolidation happens in such a manner. For example, there are five entities in a group. So assets of all the five entities are clubbed together. Assets of all the five entities, the liabilities are consolidated together in such a manner that the five entities are treated as one for the purpose of CIRP. So what IBBI is proposing at this stage is with respect to explicit provisions dealing with procedural coordination in case of interconnected entities. We'll be understanding the details of what exactly is procedural coordination in the later segment of our today's video. Second is with respect to concurrent invitation of plans for CD as a whole as well as for specific assets. So as per the existing provisions, first of all, the RP needs to invite plans for the CD as a whole, and if that does not helps in getting good plans, then plans can be invited for specific assets as well. So that generally takes a longer time because first we have to invite plans for CD as a whole, and if that fails, then we call for individual assets. So now what is proposed for the purpose of minimizing the time front, both of these activities can happen concurrently. Third is another significant introduction, which is providing for the provisions for two-stage approval of resolution plans at NCLT level. So in the two stages, at stage number one, NCLT will be approving the funds which the resolution applicant is planning to bring in the basic procedural implementation. And in the second stage, at the subsequent hearings, with disputes with respect to intercreditor distribution and other such aspects will be dealt. The fourth proposal is with respect to review of expenditure on operational expenses, including leased properties by COC. And it is also proposed for inclusion of certain illustrations that distinguishes between what is a essential service and what is a non-essential service. So what, as per the discussion paper, it has been observed in several cases that in the name of essential services, for example, water, instead of using it for routine consumption, the water has been expenses in relation to water has been incurred for the purpose of generation of energy and certain related activities. So they are proposing to provide for examples so as to distinguish between what will amount to essential service and what will amount to non-essential service or critical service. Fifth is with respect to inviting interim finance providers to attend the COC meetings as observers. So this is important. For the purpose of, so as per the discussion paper, what they are proposing is to incentivize the interim finance providers. The interim finance providers are proposed to be appointed as observer. So this is important. So the rights of observer is limited to only observing what is happening in the COC meeting and is not privy to, is not allowed to vote in the discussion which is taking place. However, to what extent the same will be incentivized on the part of interim finance providers, that also we'll be discussing in the later segment. Sixth is with respect to disallowing modification in the resolution plan post approval of NCLT. So once the NCLT has approved the plan, subsequently no modification in the plan will be allowed. Seventh proposal in relation to CIRP is with respect to presentation of all the resolution plans before the COC. So generally what happens, the resolution professional screens out all the plans, and after that only those plans which meet the statutory requirements are placed before the COC for its approval. But now it is proposed that all the plans, whether they are in compliance or not in compliance with the existing provisions, all the plans will be put before the COC. Eighth proposal is with respect to mandatory submission of statement of affairs by the CD in case of Section 7 applications by financial institutions. So once again, this particular thing is critical in the sense, whenever a Section 7 application is filed, when the corporate debtor is given an opportunity to file its reply, along with its reply, it also needs to submit a statement of affairs. But this requirement will come in only when the application is preferred by a financial institution. Now, it is also significant to note that in case of financial creditors, real estate allottees are also a part of financial creditor, but they're not financial institutions. So, is IBBI proposing to limit this particular requirement only in cases when the application is filed by financial institutions? That also we need to understand. Ninth proposal is with respect to enhanced disclosure requirement for avoidance transactions, which also we'll be understanding in detail. So that is the proposal in relation to CIRP. Next, when we come to liquidation, there is a significant proposal that proposes that the provisions in relation to going concern sale during liquidation to be omitted in entirety. So the idea behind this proposal in brief is, if the corporate debtor could not be sold off as going concern during CIRP, then there is no question of moving it ahead in case of taking this particular thing ahead in case of liquidation as well. This also we'll be understanding in detail while we reach to the liquidation segment. And the last proposal is under insolvency resolution of personal guarantors, wherein the procedural pathway is now proposed where there's a so if the repayment plan is received, then if the repayment plan is not received for the insolvency resolution of personal guarantees, then there was a vacuum as to what will happen next. So now they are trying to bring out the clarity in this case and are proposing that even if there is non-receipt of any repayment plan, so at that stage also the bankruptcy application can be preferred. So that is all about the snapshot of the proposed amendments. Now I request Shikha ma'am to take the discussion forward and help us understand in detail what are the proposal in relation to CIRP. Over to you,
Thank you,
ma'am.
Neha. Thank you, Neha, so much for summarizing things in brief and succinct way. I'll just proceed to discuss regarding the first important proposal, which is regarding introduction of coordinated insolvency resolution for interconnected entities, which we usually name as procedural coordination. In general terms, it is known as procedural coordination. So it's not the first time basically the legislators or the regulators are pondering over it. There has been a long trail of discussions starting from say 2019, in fact, when various working groups, various committees, and even MCA had come up with such proposals and detailed discussions around it to introduce certain provisions relating to group insolvency. We know that there have been many cases, for example, Videocon, Airtel, where these concerns relating to group consolidation or group coordination arose, and therefore there is a need felt that there has to be some sort of concrete provisions in the law itself, which would facilitate and make things uniform for all the stakeholders. So, coming first to what the proposal is basically by way of insertion of Regulation 40E in CIRP regulations. Um, Before that, I would just give a context to it. In the year 2023, MCA also had come up with a similar discussion paper where they dealt in detail relating to group insolvency. And there they proposed amendments in the code itself, but probably the same could not fructify, and therefore IBBI is coming up with proposals for amendments in the regulations only. So there is, while the topic itself is so vast, but we see that the proposal only kind of looks into a simple one regulation provision, which is Regulation 40. So first, let us go through what the proposal is. I'll just show the regulation here for the benefit of all. So this is the proposed Regulation 40E, which talks about coordination of interconnected entities. It starts with where two or more CDs undergoing CIRP process are interconnected. So basically, there has to be two or more CDs which are undergoing CIRP, and these CDs must be interconnected. So three conditions we can look into. Number one, CDs undergoing CIRP, which means these CDs must have committed some sort of default, and therefore they are under CIRP, which makes it amply clear that solvent entities in the group cannot be included. That is number one, and that has been the consistent approach of all the working groups, committees, and even the UNICITRAL model law, that solvent entities should not form part of group insolvency unless there are exigencies around it. So there has to be, of course, consolidation would happen if there are two or more than two such entities. Third, these entities should be interconnected, which means now how will we determine that these entities are interconnected? See, there can be various parameters to assess the interconnectivities. For example, too much of related party transactions between the parties, too much of intermingling of assets and liabilities, etc., etc. However, there can be a lot of subjectivity around it. Therefore, what the law does is to specify two broad parameters, which is existence of control and existence of significant ownership. So at the first blush, one might think of this is significant influence, but no, this is not significant influence. This is significant ownership. So how do we determine whether there is a control or not? And how do we determine whether there is a significant ownership or not? We go back to the explanation to this sub-regulation, which links the definition of control to the definition of Companies Act. Now, as per Companies Act, a majority shareholding or majority of voting power or majority to appoint board of directors, the right to appoint majority of the board comes under the purview of control. And with respect to LLPs also, they have specified certain criteria. When it comes to significant ownership, it is, as I said, it is distinct from significant influence, which has a threshold of 20%. Here it's not 20%, it's ability to exercise 26% or more voting power. See, here we are talking about the ability to exercise. Whether I do exercise this power or not does not matter. I should have the ability to exercise 26% or more voting power. If these conditions are met, say if one entity is controlling the other entity, or if one entity is significantly owning the other entity, then these two entities can be consolidated, subject to the fact that these entities must have committed a default. Now, how the coordination process would initiate? So here the post regulation says the RP of any such CD. So say suppose if there are two CDs A and B, the RP of A or B can file an application with the adjudicating authority for coordinate conduct of the processes. Now, coordinated conduct, what do we mean by coordinated conduct? So there again, we need to jump to sub-regulation 2, which says the adjudicating authority may have satisfied that there has to be certain criteria which AA should get satisfied with. It can pass orders for joint hearings, So basically, I'll hear both the cases simultaneously. Appointment of a common RP, I can appoint a common RP. I'll ensure information sharing between the different, if suppose there are different RPs operating or conducting different CIRPs of these two series, say, then there has to be proper information sharing. So as we move ahead with the discussion, we'll say this information, we'll see that this information sharing is not only important between the resolution professionals, but also between different other stakeholders, for example COCs, for example the adjudicating authorities. So this cooperation and information sharing are the fundamental brickstones of procedural coordination. Now, coordination of timelines. So of course, say suppose CIRP of one entity might be taking a longer time than the other. So how do we coordinate and go about the timelines there? And any other measure as it deemed fit. So while it looks like there are only 5 points to this coordinated conduct, but if we go into details, we would see that across the entire literature pertaining to group insolvency, there are much more granular nuances of this procedural coordination. We'll discuss that in brief as to how that takes place as the time permits. Now, this again, coming back to the formalities. So the RP will make an application. So of course, the RP is simply the, the ringmaster. He cannot do things on his own. So he'll have to take the approval of COCs. So now the language is a little dicey. It says, subject to obtaining prior approval of each committee of creditors by a vote of not less than 66% in values, voting in that. So present and voting ka concept is already there under IBC. So here the RP will have to ensure that if there are, say, suppose two CDs, the COCs of both the CDs have given prior approval to this coordinated conduct of processes. Now, say suppose I am a RP, I want to go for coordination of another entity, say entity B. I might have to approach the COC of the entity B through their RP to ensure that I can make an application for the purpose of coordination. So the process of, I would say, coordination starts right before any application is filed before the adjudicating authority. So that's about the formalities. Next, say suppose I filed an application by taking approval of COC. Now, adjudicating authority also has to weigh in certain parameters while going ahead with this proposal. So the adjudicating authority, if satisfied that coordination would be in the best interest of the corporate debtors and their stakeholders. So this is again one such circumstantial and subjective criteria which the AA might need to delve into. So basically the RP, which who is making the application to the AA, will have to make a case before the adjudicating authority to prove that this coordination, if ordered, will actually be in the best interest of the CD and their stakeholders. So before we get into various questions surrounding this proposal, let us understand what can be the possible factors basis which the adjudicating authority may actually determine that whether this order of coordination would be beneficial for the CD or not. So I'll just move to the second slide. So these are the various factors. So the extent of intermingling between the intermingling of the management, the business and finances of the companies. The higher the extent of intermingling, the more chances that the group insolvency would be more beneficial. Where there are few interconnectivities, the group insolvency might be in fact not advantageous, might be disadvantageous given the costs involved. So we have to, the adjudicating authority might have to see the extent in which this interconnectivities are there. So next in line is with the when the creditors are dealing with a company, are they seeing the company as a separate single entity, or are they also banking upon the group as a whole? So what is the general perception of the entity and the group in the eyes of the creditors? That also matters. The most important aspect is what would be the effect of such measures on creditors? Are this whether this coordination, or whether this approach to group insolvency will actually lead to better realization and synergies, or would incur higher cost other than rather than in the usual course? So these might be some possible factors where the applicant RPs or the applicant COCs might need to satisfy the adjudicating authority to weigh in whether this sort of coordination should be ordered or not. Now, coming to various questions, I talked about that CDs must be undergoing CIRPs. For example, now what about the cases where the CIRP has not been initiated? There are suppose 2, 3 entities in the group, and I know that all these 3 entities have defaulted. As a financial creditor, can I go ahead and file a joint application? See, the language of the proposal is not very clear on that. In fact, it does not talk about joint application, but all the group insolvency literature which we see do talk about joint application, and they do enable joint application by the applicant against 2 or more entities. So it shouldn't be a problem. This IBBI can maybe consider while finalizing the proposals. Now, talking about the nuances, whether there would be a common COC around it. The proposal talks about a common RP. So whether there would be a common COC. Now coming to COC, the literature around group insolvency talk about a holistic framework agreement, or say you can call it a group strategy. At some places it has been called a group strategy, which talk about the entire plan or the entire schedule in which these group proceedings would be coordinated. So they might provide for in general, they do not provide for a common COC. They provide for constitution of a COC having members from different COCs, but they would not take decisions. They would be solely for the purpose of coordination and discussions. Decisions would be taken at individual level of CDs. So if there is CD1 and CD2, and if there are COC1 and COC2, each COC will take its own decision. However, there would be a group COC formed, which will have members from COC1 and COC2. They will be relevant for the purpose of all coordination and communication and information sharing purposes. They won't take decisions at the group level. So we need to first understand that we are not talking about consolidating the proceedings here, as in we are not going across the assets and liabilities. We are simply talking about coordinating the processes, as Neha explained earlier. Now, whether common resolution plan would be invited, it is quite possible, going by what framework, what group insolvency plan the members, the COCs draw, the RPs draw. It's possible that a common resolution plan would be invited. However, the claims and the respective assets, the respective claims against each of the entities would be duly respected. There would be no intermingling of claims as well as any security interests. For example, if COC, if there is a creditor sitting again, sitting in the board in the COC1 in CD1, it has an exclusive security interest over some of the assets of say CD1. It cannot, and that say suppose that asset has depleted, it cannot claim its security against the assets of CD2. So that's where lies the difference between substantive consolidation and procedural coordination. In procedural coordination, there can be no mixing of assets and liabilities, but in substantive consolidation, if the situations and so permit, there can be such, one creditor can lay hands over the assets of the other entities as well. So that's not the case here for the time being. Now, avoidance proceedings, whether there would be any specific provision for subordination of debts of group entities, it's not there in the proposal. However, certain proposals in the past have been there where it has been left to the discretion of adjudicating authorities. Solvent entities in the group, as I said, will not be included. Okay, there can be various costs included for the purpose of coordinating these entire orchestra, right? So what would happen to these costs? Who would bear these costs? So there is nothing regarding that in the proposal. However, going to the past working group reports, etc., this again has been left to the group plan, which I talked about. So I just first, before talking about what are the broad differences between procedure and substantive consolidation, I'll just go through some of the important recommendations made in the past to discuss, how this procedural coordination might actually work. See, in 2019, there was working group on group insolvency chaired by Mr. UK Sinha. It recommended a framework agreement for group coordination proceeding amongst the COCs of the participating CDs. So there can be an IP who can act as a group coordination. It might also be possible to propose an invitation of a common expression of interest and resolution plan. Now it is again, it was left to the flexibility of COCs as per their discretion. They can opt to, participate in the group proceedings or opt out of it by way of voting by majority. Now there has to be a a single adjudicating authority, and also there was one important aspect regarding timelines. Wherever these group insolvency proceedings would be there would be an additional timeline of 90 days. For example, it's written here, to account for the additional time these proceedings may take to enable the value maximizing resolution. The current proposal does not talk about any such additional timelines. We also need to understand that these timelines are currently coming from the code itself. So we are not sure whether these sort of amendments can actually be made in the regulations. Similarly, when we see the CBIR's cross-border insolvency regulations committee report on group insolvency, which came out in 2021, it also provided for similar group coordination proceedings, where they envisaged the appointment of a group coordinator and development of a group strategy, where which would provide various aspects relating to the conduct of group proceedings. So last but not the least, depending upon what is the extent of uh, reaching out to the assets and liabilities of the CDs, participating CDs, the group insolvency can either be procedural coordination or substantive consolidation. Neha has already explained that in case of procedural coordinations, we are only coordinating the procedures, but in case of substantive consolidation, we are disregarding the legal entities of the respective CDs, and we are seeing the group and the enterprise as a whole to merge the assets and liabilities. So there the inter-entity claims of creditors would vanish and would rather intermingle as all other assets and liabilities of the entity. So I think this is about the proposal. Maybe there are certain points where the proposal might need to be improvised in terms of granularities, looking into various committee reports and all. We will accordingly be giving comments to the IBBI. I'd request Barsha to take this discussion forward regarding other proposals in the uh, IBBI proposal. Thank you.
Thank you, Shikha. So I'll just share my screen to continue this further.
I'll just stop sharing.
Neha, please confirm once whether my screen is visible.
Yeah, it is visible now.
Okay, so now that Shikha has discussed regarding this proposal with respect to group insolvency, we'll continue further with the further proposal that has been made by IBBI. As we all know that CIRP, be it liquidation, it's a evolving law. So based on the practical difficulties that insolvency professionals are facing or the procedural gap, IBBI makes amendment from time to time, and that is also subject to the discussion based on the proposal by the respective insolvency professionals as to what they think about the changes that IBBI is proposing or not. So now there are several proposals which has been again placed by IBBI. We'll continue further with the further proposal that has been made. So the second one is about part-wise resolution plan for the corporate debtor. So first, I'll just discuss as to what was a concern. So concern was with respect to regulation 36B, sub-regulation 6A, wherein it was categorically mentioned that only after the attempts for inviting the resolution plan for the corporate debtor as a whole, the resolution professional could invite the resolution plan for the specific assets of the corporate debtor. So this, of course, cause extension of timelines, extension of CIRP timelines. This again caused the further loss of value of the assets, etc. So of course, it's a thought to make a simultaneous presentation of the resolution plan, simultaneous invitation with respect to the resolution plan, such that the prospective acquirer may accordingly put forth their plan, whether they intend to acquire a specific assets or they intend to acquire the entire corporate debtor as a whole. So just to avoid the wastage of time, this proposal has been given that simultaneous proposal can be given, simultaneous proposal with respect to the corporate debtor as whole or for the specific assets of the corporate debtor. However, what will be the procedure to be followed for this? As to say, suppose if one particular SRA is submitting expressions for both the kind of invitation, for the corporate debtor as whole as well as for the specific assets of the corporate debtor. What will happen in that scenario? So maybe the detailed plan or the detailed proposal, once it's there, we'll be able to understand the actual thought behind this proposal as to how this procedural gaps can be covered by IBBI. Next, coming to the next proposal, which is with respect to dual stage approval of resolution plan. So this is with respect to regulation 39AA of CIRP regulation. This particular insertion says that the committee may, by a vote of not less than 66% of voting shares, recommend to the adjudicating authority to first approve the implementation of the plan and thereafter approve the manner of distribution. So this is again to avoid the unnecessary delay. So once the plan is there, the idea behind this proposal is to continue with the proposal, continue with the implementation thereof, and subsequently the matter connected thereto, be it the disputes connected to the same, be it the distribution related concerns, etc., that can be dealt with in a second stage. So it's about dual stage plan. First stage, once the plan is there, that implementation will follow, and in the second stage, COC will think or COC will decide as to how the distribution process will follow. Coming to the next proposal, which is regarding the review of expenditure on goods and services availed during CIR. So the gap, particularly in this provision, was such that moratorium provided under Section 14 was applicable on essential supply of essential supply of goods and services. So what happened was that the respective IRPs, RPs, or in case of the or maybe the corporate debtor or COC, they couldn't distinguish between the specific services and essential services. So the essential services, if we say essential services, are services that are essential for the survival of the corporate debtor. So the bare minimum requirement which is required for the survival of the corporate debtor are essential. And if, say, suppose the corporate debtor is not in position to make payments towards those essential services, in that case, the moratorium covers or protects the corporate debtor, that in that case, essential supply of goods and services cannot be stopped. That is to say that even if the corporate debtor is not in position to make payments towards these essential services, these services cannot be stopped. However, what happened was the companies used to take advantage of this provision, and they used to say that since I have this moratorium, so I can use the essential supply of services or the services, even if those services forms part of the input of my output production. Like, say, suppose if the company is in manufacturing of jute or so, and that company requires huge water. So in that case, the water supply, they are using this water supply not as essential services, because this is not about the bare minimum survival of the company. This becomes a specific service for the company needs for the production, for the output of their production, for the manufacturing of their goods. So this becomes specific services. So by way of an illustration, by way of a further elaborative illustration, it has been clarified that there's a need of proper bifurcation of essential services and specific services, such that moratorium is applicable in case of essential services and not when it comes to specific services. This was very much needed, and that is why this proposal is provided. Coming to the next part, which is about interim finance providers. So this particular provision is about incentivizing further the interim finance provider. However, practically, if we see, in very few cases, the interim finances have been raised when it comes to CIRP process or so. So further incentivizing the interim finance provider by giving this opportunity as well, that they may attend the COC meetings even if they'll not have any voting rights, in our view is not needed. However, the same has been proposed. This proposal has been put forth by IBBI to have a view of the respective insolvency professional as to if this further incentivizing the interim finance providers will help them to gain or to have further attraction from them or to gain their interest with respect to providing interim finance during CRP process. As of now as well, interim finance providers get priority when it comes to their repayment of the finance that they have provided during the CRP process. So we are of the view that further inviting them or giving them this opportunity to be a part of the CUC discussion without any voting rights or whatever. So that is not needed particularly. That is what we hold a view. Coming to the next proposal, these are the procedural changes which has been proposed by IBBI. So first is about no modification in NCLT approved resolution plan. Now it says that once the resolution plan is approved, no further modification can be made thereto. We all have seen that once the resolution plan was approved by COC and then subsequently by adjudicating authority, the successful resolution applicant used to file an application, or maybe the resolution professional used to file an application with the adjudicating authority, thereby praying for several reliefs so that they can have a smooth transition of the corporate debtor of the assets of the corporate debtor in their hand. But now it is categorically mentioned, or it is categorically proposed, I would say, that no further modification can be made to a plan. So whatever relief, etc., if the SRA is intending to have, that also they have to mention in the resolution plan itself. If the particular relief is not forming part of the resolution plan, they cannot approach the adjudicating authority further for the further reliefs or so. This is primarily to give additional relief, some concession to the lengthy litigation which continues even after the CIP process. This is also to avoid the uncertainty when it comes to implementation of resolution plan. So this particular provision is proposed with an object to remove these obstacles when it comes to conclusion or concluding the CIRP process. Second is with respect to presentation of all the plans before COC. So now this proposal is also given that irrespective of whether the plan has been approved, it's complete, it's not complete whatsoever, all the plans, irrespective of the nature it has to be presented before the COC. The idea behind the same is such that COC can have a informed decision when it comes to approving a particular resolution plan. So they can see, they can ensure that the plan that finally that they are approving is complete in all senses. So to have that kind of approval, it's now proposed that COC have to the RP has to place all the plans before the COC. This again, in our view, is not needed given that the timeline provided for CIRP is it's just 180 days. So now having COC's time for each and every each and every plans that has been presented, or asking the timeline of the COC or asking the time of this COC for going through with each and every plan, even if that plan is not complete in all the manners, will ultimately waste time of the COC and will be time consuming, will not be in line of the ultimate intent of this code. So in our view, this proposal is may not be considered or should not be considered further for the purpose of implementation. Coming to the next part, which is very important part, which is about statement of affairs by the corporate debtor. So what this proposal is about? This proposal is about mandating the corporate debtor to submit their reply, or at the time of submitting their reply, to submit a complete statement of affairs. So as we all know that it is it has happened in so many cases that after commencement of CIRP, the resolution professional has to have a lengthy proceeding, or they have to make a huge effort to have the details of the corporate debtor in hand. details to continue with the proceeding further, details to have the financials of the corporate debtor in hand. So it has become a cumbersome task for the corporate debtor as well to, for the resolution professional as well to continue with the process further. So now it is mentioned that if the opportunity has been given to the corporate debtor to submit their reply, so at the time of submitting their reply itself, they have to mention about the statement of affairs, what all assets are there, what all liabilities are there, what is the statement of affairs, what is the condition of their financial situation, etc. So all the details they have to mention along with the reply itself, so that the process, the unnecessary delay in the process can be avoided. So at the very time when the process is getting admitted, the IRP will have the statement of affairs in hand and can accordingly process further or with the CRP process. Next is about enhanced disclosure requirement for avoidance transaction. This particular provision now talks that in the information memorandum itself, details with respect to avoidance transaction should be provided. And as and when there is any development, those developments should also be updated with the IM. So the updated IM should be there, updated information memorandum should be there, should be presented before the COC and should also be presented for the resolution applicant as well, so that they can have an informed decision while submitting their resolution plan. There should not be anything which is concealed from the resolution applicant. So while submitting their plan, they should submit a complete plan, having considered the entire details with respect to avoidance transaction and assignment thereof or the treatment thereof, what they are thinking in the plan itself. Coming to the next very important proposal of IBBI, which is about omitting going concern sale requirement from the liquidation. Liquidation regulations contains several modes of realization of the assets of the corporate debtor or the corporate debtor as a whole. One of the most important mode was going concern sale. This was subsequently added to make it convenient for the successful acquirer, for the prospective acquirer as well, to give them a chance so that they can take the benefit of the connected to the corporate debtor after acquiring the corporate debtor as well. So if say suppose during resolution plan the SRA could not submit the plan, during CIRP if the SRA could not submit the plan for the revival of the corporate debtor, they get an opportunity during liquidation as well for the revival of the corporate debtor by way of this going concern sale. So there were two modes added. One was with respect to going concern sale of the corporate debtor as a whole, and the second one was with respect to going concern sale of a business of the corporate debtor. Now it is proposed to remove both of these modes. The very idea behind seemingly maybe that either the corporate debtor will remain a going concern or it will be a gone concern. There will be no further opportunity be given to revive the corporate debtor further. So this is all about the proposal that has been made by IBBI. Over to you, Neha.
Yes, ma'am. So that is it from our end for this particular video. I thank Shikha ma'am and Darshini ma'am for this detailed discussion of the different proposals. So that is it. Thank you, everyone.
Neha.